I was meeting with an attorney in my office this morning about a call that he received in which it was a current employee. And the attorney was wondering what advice we can give them because they had filed a claim against their employer, and they felt like they were being retaliated against here in California for making those complaints. And the attorney and I sort of walked through those issues as to what the employee actually complained about and who they complained about that conduct to. My questions were, did they complain just internally? Did they complain just locally, or did they complain to human resources? Did they complain verbally? Did they complain to a hotline? And did they complain in writing? And we sort of walked through all of those issues. I don't want to get too specific into this person's claim, but all of those questions are relevant as to whether or not your claims, what the next step should be. Sometimes we have claims in which the employee actually went outside of the employer, that they contacted OSHA, or they contacted the EEOC, or they contacted the DFEH. I set up a meeting with this potential because I think it was important for them to understand that just because you complain to your employer doesn't mean that your employer's conduct is towards you is going to be unlawful. The first step is to sort of determine what you complained about. Is it protected? Did you complain about conduct that's unlawful? And who did you complain to? So that's sort of the first step, is ensuring that is your complaint going to be protected under either California law or federal law? The next step is assuming that what you complained about is protected under the law. How do you document that? How do you ensure that at the end of the day, there won't be a dispute as to whether or not what you complained about was lawful? There's a lot of cases in which the employer throws up their hand and says, no, there's no record of them ever complaining. And my client says, I raised it to 3 people in the same meeting. And now it's them denying it. So it's always helpful to figure out who you complained to and how you complained. If it's just you against the world, if it's just you against 3 managers, that doesn't mean you didn't complain. It also doesn't mean that you can't win your case. A lot of our cases have facts in which there is no written documentation. Now, I'll be honest, it's always easier that if there's some contemporaneous notes or some contemporaneous email that goes out. This is to confirm the conversation we had in which I raised these issues. And so that's one issue. Is one, again, making sure what you're complaining about is protected under the law. 2, that it's always helpful to have some kind of documentation that you did call. And then 3, if all that's happening and you're still being retaliated, then the question is, what's the next step? As to that next step, as to what you should do in California, I would encourage you to talk to an attorney, because you're currently going through stuff that you don't want to happen to you, that you just want the harassing conduct to stop, the discriminatory conduct to stop, the retaliatory conduct to stop. If you feel like you need to talk to an attorney to assist you in that, I would encourage you to talk to an attorney, especially an attorney that practices employment and labor law. If I can answer any of those questions for you, feel free to give us a call. I'm happy to talk to you about all 3 steps. Whether or not the conduct that you're complaining about is unlawful, to how you should complain, and 3, how you should address any discrimination, retaliation, or harassment as a result of those complaints. So again, if you have questions, always feel free to give us a call. We're more than happy to help.